Today on Legally Us, Leah McSweeney takes on Bravo as Shannon Beador is officially charged. Plus, Taylor Swift is changing the game once again. We got that plus so much more on today's Legally Us. Everyone, and welcome to Legally Us. I'm Christina. That's, of course, Neama Rahmani, President and CEO of West Coast Trial Lawyers. Hi, Neama. How are you?
Doing great, Christina. How about you?
Doing good, doing good. We have a lot of Bravo stories going on this week, so let's get right into it. Starting off with Leah McSweeney. So the former Real Housewives of New York star filed a discrimination complaint against Bravo after filming Real Housewives Ultimate Girls Trip earlier this year. So she and her lawyers filed this back in March, citing an alleged violation of the Americans with Disabilities Act. Now, this is according to a bombshell article that was published by Vanity Fair. So in a wide-ranging investigative piece on the franchise, McSweeney described her tumultuous time on the show, from relapsing on season 12 of Real Housewives of New York City to missing her grandmother's death during a Hamptons trip the following year, and said that castmates encouraged her to drink. Now, an attorney for Bravo, Shed Media, and its parent company, Warner Brothers, denied her claims of discrimination back in May. So she claimed that she was pressured to drink on the show, that she relapsed. What could happen to Bravo in this case, considering they knew about her alcohol abuse in the past?
This is going to be a tough case to prove. And, normally when you sign these types of agreements on reality shows, there's significant disclaimers and waivers. And ultimately, whenever you're dealing with a discrimination claim as an employee, there has to be some sort of adverse action. And alcoholism can absolutely be a disability. So if you notify your employer that you have this disability and they terminate you or retaliate against you, you may have an employment claim. The question is, does encouraging one to drink when you have an alcohol or substance abuse problem, is that an adverse employment action? Probably not. Going to be a tough claim to prove. I mean, that being said, Bravo is under fire. There's been a lot of issues recently, potential unionizing, getting bad press. But really the question is, if you join a reality TV show and the Real Housewives franchise, it involves a lot of drinking. I mean, the question is, if you have an alcohol problem, is that something that you should be doing as someone who's talent or an employee? Probably not.
Probably not. And like you said, I'm sure Bravo has these ironclad contracts for stuff like this not to happen. Otherwise, they probably would have numerous lawsuits on their hands because, a lot of housewives like to drink.
Yeah, and I've reviewed these agreements, and they say that, look, there might be drinking, there may be fights, there may be assaults, and the talent, they often waive their right to bring claims against either the production company or the studio. So, and that's something that, you can waive your right to file a lawsuit. So I think step one, before we even get to any potential employment claim, whoever's representing her is going to have to litigate the release that she signed.
All right, moving on over to Shannon Beador. We've talked about this numerous times, but she has been officially charged with a hit and run and DUI 1 month after her September arrest. According to documents, she was charged by the Orange County District Attorney on October 27th with 1 count of driving under the influence of alcohol and a 2nd count of driving under the influence with a blood alcohol level more than 0.08. They actually said that she was 3 times the legal limit when they booked her. So she was also charged with 3rd count of a hit and run with property damage. All 3 charges are classified as misdemeanors. So if they're classified as misdemeanors, what does that exactly mean, and what will happen to Shannon going forward?
So a misdemeanor is punishable by a year or less in jail. And I don't expect her to necessarily get any jail time, but there are certain enhancements that, Orange County District Attorney Todd Spitzer can file. And one of them is if your blood alcohol content is over 0.15, which it was. That's almost twice the legal limit. She's well over that. So, someone who, not only was driving under influence, but got involved in an accident and, tried to walk away from the scene, the law considers that fleeing the scene. She doesn't have much of a defense here. This is the type of case that she's going to have to plead out, do her classes, it could be AA or Mothers Against Drunk Driving, do her probation, pay very significant fines. And What she may actually have, and depending on the county, she may actually need an interlocutory ignition device. So that would require her to blow in her vehicle to make sure there's no blood alcohol content before it starts.
Interesting. And then most likely she'll probably get her license taken away for a period of time as well.
Yeah, so the driver's license case is a separate case. It's an administrative case before the DMV. So you have your criminal case and you have your administrative case. She's very likely going to get her license suspended. Although technically, theoretically, it's possible that you can win the DUI case, lose the DMV case, or vice versa.
Mm-hmm. You know, we're pretty sure that she came from her ex's house when she was driving. But if she had left a bar, a restaurant, establishment, would that place also be held accountable for letting her get behind the wheel?
It's a great question, Christina, and it really depends on the state. This is one of those areas where laws in different states differ. And the type of law that we're talking about is a dram shop law. California does not provide for liability on restaurants and bars for serving people. Now, there are some exceptions, obviously if, you're serving minors or potentially very obviously intoxicated people, maybe you can get around that law. But generally speaking, in California, you can't sue an establishment for serving you, and then if an injury results.
Moving on over to Taylor Swift, because record labels are introducing new changes to their contracts inspired by Taylor. She's changing the game all over the place. So in light of her success, labels are ready to enact new clauses to prevent future artists from devaluing their original work. So major record companies such as Universal, Sony, and Warner Music Group are set to introduce stricter contract terms for artists demanding longer waiting periods before they can re-record their music. These waiting periods, typically 5 to 7 years from the release date of the original or 2 years after the contract expires, have now been extended to 10, 15, or even 30 years. However, some artists and their attorneys are pushing back against these new restrictions. So will the record labels or will the artists win out in this? Because, if you're pushing re-recordings 10, 15, 30 years later, people may sound completely different. It just seems like they are just trying to push this off as far as they can, seeing how successful Taylor was in doing this.
Yeah, well, Taylor Swift is clearly changing the game. And we talked about how she's revolutionized potentially the movie industry and now the music industry. And, the newest billionaire in the United States, she's certainly a unicorn and a great business mind as well. So obviously, Taylor Swift is unique in that her songs have been popular for decades, and she has a leverage that maybe a lot of folks won't when they're trying to get their record deal. But if you're asking me as a lawyer from a legal perspective, this is purely a contractual matter. You can agree to anything you want. We talked about the Housewives franchise, right? If you want to be on the show, you agree to release your claims. Well, an artist can agree to have the record companies own the intellectual property and the rights indefinitely, or they can have a much shorter period. And someone like Taylor Swift is really raising awareness about how important these re-recording rights are, and the parties can agree to anything that they want.
Yeah, it's going to be hard for, up-and-coming artists that want that record deal, and then who knows if they become the next Taylor Swift, they might be stuck. Who knows? It's very interesting how she keeps kind of revolutionizing the way that business is going for record labels and movie industry. So, all right, well, I feel like I'm a broken record because I say it each and every week, another Kroy and Kim story, but here we are again. They are doing everything they can to prevent foreclosure on their shared Georgia mansion. So the couple each filed affidavits last week outlining the ways in which foreclosure would hurt their family. So the pair put their home on the market earlier this month after Us Weekly confirmed in February that the property was in foreclosure. The affidavit states that they would be left homeless, without financial resources, and unable to address the debts accumulated during their marriage. Among these debts are the Truist mortgage, a home equity line of credit on the property, and an IRS lien. So Kroy also noted that he worked closely with Truist to avoid foreclosure by entering a 3-month probationary payment period from June to August of 2023. But they were unable to make their August payment due to the challenges arising from an ongoing divorce. So Kroy emphasized that the property is currently on the market in accordance with a court order from the judge presiding over the duo's divorce case, and the sale would ensure that he and Kim would be able to pay back Truist in full. So when couples come to a judge or things like that and basically be like, we're going to be homeless if this doesn't go through, did they take that into consideration, or is this completely business?
It's completely business, Christina, and it's not a legal defense. Might be sad. I don't know if they're really going to be homeless, but even if they were, not a legal defense in the case. Now, there's certain types of proceedings that might stay or put a foreclosure on hold. The most notable is a bankruptcy. But getting a divorce does not put a foreclosure on hold. So whether it's a mortgage or a deed of trust, the reason the lender gives the loan is that that loan is secured on the property, right? It's called a secured transaction, or a real property interest. So if you don't pay, then they can go get that property. That's the whole point of the mortgage. So they haven't paid. The lender has the right to foreclose, and their affidavit might be sad, but it's not going to have any legal effect to stop the foreclosure.
Why? I mean, we've talked about this time and time again, but why haven't they filed for bankruptcy at this point? I mean, is that something that you would advise, even though that's probably the last resort? But it seems like at this point, it might be their only option.
I'm surprised they haven't filed bankruptcy, but once you file bankruptcy, all of your assets, all of your debts become part of that bankruptcy estate. So I don't know what they have and whether they want to give it all up to pay their debtors, but I think ultimately that's where they may and probably should end up.
Well, I'm sure we'll be talking about it next week as well, Neama. But that is it for this week. Thank you so much for your insight and expertise as always.
Thanks, Christina. See you next week.
For more news, content, and exclusive interviews, make sure to hit the sub, like, and bell button down below and visit usmagazine.com.